Marriage requisites. Case of the Family Code, Law on Marriages. Trigger your mind. This is a collection of answers. I know you know the law. The purpose of this is to trigger your mind. Subscribe and comments below. Family Code. Marriage requisites. Case of the marriage is voidable. The consent of the parties to the marriage was defective. Being below 21 years old, the consent of the parties is not full without the consent of their parents. The consent of the parents of the parties to the marriage is indispensable for its validity. B. Between 21-year-olds, the marriage is valid despite the absence of parental advice because such absence is merely an irregularity affecting a formal requisite, i.e., the marriage license, and does not affect the validity of the marriage itself. This is without prejudice to the civil, criminal, or administrative liability of the party responsible therefor. C. By reason of public policy, the marriage between Filipino first cousins is void. Art. 38 Par. 1. Family Code, and the fact that it is considered a valid marriage in a foreign country, in this case, Spain, does not validate it, being an exception to the general rule in Art. 96 of said code, which accords validity to all marriage solemnized outside the Philippine XXX invalid there is such. D. It depends. If the marriage before the notary public is valid under Hong Kong law, the marriage is valid in the Philippines. Otherwise, the marriage that is invalid in Hong Kong will be invalid in the Philippines. E. Under the local government code, a town mayor may validly solemnize a marriage, but said law is silent as to the territorial limits for the exercise by a town mayor of such authority. However, by analogy, with the authority of members of the judiciary to solemnize a marriage, it would seem that the mayor did not have the requisite authority to solemnize a marriage outside of his territorial jurisdiction. Hence, the marriage is void, unless it was contracted with either or both parties believing in good faith that the mayor had the legal authority to solemnize this particular marriage. Art. 35. Part 2 Family Code. Marriage requisites. Marriage license. Case the marriage is valid. The irregularity in the issuance of a valid license does not adversely affect the validity of the marriage. The marriage license is valid because it was in fact issued by a civil registrar. Arts. 3 and 4. FC. Case the marriage would be void because of the absence of a formal requisite. In such a case, there was actually no valid marriage license. Marriage requisites. Marriage license. Case A. The marriage when quercia is void. The exemption from the requirement of a marriage license under Art. 34 Family Code requires that the man and woman must have lived together as husband and wife for at least 5 years and without any legal impediment to marry each other during those 5 years. The cohabitation of Facundo and Quercia for 6 years from 1990 to July 1, 1996, when Putcher died, was one with a legal impediment, hence not in compliance with the requirement of law. On other hand, the cohabitation thereafter until the marriage on July 1, 2000, although free from legal impediment, did not meet the 5-year cohabitation requirement. Case B. A void marriage may be questioned by any interested party in any proceeding where the resolution of the issue is material. Being a compulsory heir, Sotero has the personality to question the validity of the marriage of Facundo and Quercia. Otherwise, his participation in the estate on Facundo would be affected. 9 v. Baydock 328 SCRA 122 2000. Marriage requisites. Solemnizing officers. Case 1. Yes, the marriage is valid. The Family Code took effect on August 3, 1988. At the time of the marriage on September 4, 1987, municipal mayors were empowered to solemnize marriage under the Civil Code of 1950. 2. The marriage is not valid. Consuls and vice-consuls are empowered to solemnize marriages between Philippine citizens abroad in the consular office of the foreign country to which they were assigned and have no power to solemnize marriage on Philippine soil. B. A Philippine consul is authorized by law to solemnize marriages abroad between Filipino citizens. He has no authority to solemnize a marriage in the Philippines. Consequently, the marriage in question is void. Unless either or both of the contracting parties believed in good faith that the consul general had authority to solemnize their marriage, in which case the marriage is valid. Marriage requisites. Void marriage. 1. The marriage of A and B is void because the solemnizing officer had no legal authority to solemnize the marriage. But if either or both parties believed in good faith that the solemnizing officer had the legal authority to do so, the marriage is voidable because the marriage between the parties, both below 21 years of age, was solemnized without the consent of the parents. Art. 35 Par. 2, and Art. 45 Par. 1. Family Code. 2. Either or both of the parties cannot contract marriage in the Philippines with another person without committing bigamy, unless there is compliance with the requirements of Article 52 Family Code. Namely, there must be a judgment of annulment or absolute nullity of the marriage, partition and distribution of the properties of the spouses, and the delivery of their children's presumptive legitimacies, which shall be recorded in the appropriate civil registry and registry of property, otherwise the same shall not affect third persons and the subsequent marriage shall be null and void. Arts 52 and 53. Family Code. Marriage, void marriages. If Bonnie is still a Filipino citizen, his legal capacity is governed by Philippine law. Art. 15 Civil Code. Under Philippine law, his marriage is void because of a prior existing marriage which was not dissolved by the divorce decreed in Oslo. Divorce obtained abroad by a Filipino is not recognized. If Bonnie was no longer a Filipino citizen, the divorce is valid. Hence, his marriage is valid if celebrated in accordance with the law of the place where it was celebrated. Since the marriage was celebrated aboard a vessel of Norwegian registry, Norwegian law applies. If the ship captain has authority to solemnize the marriage aboard his ship, the marriage is valid and shall be recognized in the Philippines. As to the second question, if Bonnie is still a Filipino, and can file an action for declaration of nullity of her marriage to him. Marriage, void marriages. Even if the minister's license expired, the marriage is valid if either or both Gigi and Rick believed in good faith that he had the legal authority to solemnize marriage. While the authority of the solemnizing officer is a formal requisite of marriage, and at least one of the parties must belong to the solemnizing officer's church. The law provides that the good faith of the parties cures the defect in the lack of authority of the solemnizing officer. The absence of parental consent despite their having married at the age of 18 is deemed cured by their continued cohabitation beyond the age of 21. At this point their marriage is valid. See Art. 45 Family Code. The marriage between Juliet and Rick is void. First of all, the marriage is a bigamous marriage not falling under Article 41, Art. 35 for Family Code. A subsisting marriage constitutes a legal impediment to remarriage. Secondly, Juliet is below 18 years of age. The marriage is void even if consented to by her parents. Art. 35(1) Family Code. The fact that Rick was not aware of her real age is immaterial. Juliet can file an action for the declaration of nullity of the marriage on the ground that he willfully caused loss or injury to her in a manner that is contrary to morals, good customs and public policy. Art. 21 New Civil Code. She may also bring criminal actions for seduction, falsification, illegal marriage and bigamy against Rick. I would file an action to declare the marriage between Juliet and Rick null and void ab initio, and for Rick's share in the co-ownership of that marriage to be forfeited in favor and considered part of the absolute community in the marriage between Gigi and Rick. Arts. 148 and 147 Family Code. I would also file an action for damages against Rick on the grounds that his acts constitute an abuse of right and they are contrary to law and morals, causing damages to Gigi. See Arts 19, 20, 21. New Civil Code. Marriage, void marriages, psychological incapacity. Psychological incapacity is a mental disorder of the most serious type showing the incapability of one or both spouses to comply the essential marital obligations of love, respect, cohabitation, mutual help and support, trust and commitment. It must be characterized by juridical antecedents, gravity and incurability, and its root causes must be clinically identified or examined. Santos v. CA 240 SCRA 20, 1995. B. In the case of Santos v. Court of Appeals 240 SCRA 20, 1995, the Supreme Court held that being of unsound mind, drug addiction, habitual alcoholism, lesbianism or homosexuality may be indicia of psychological incapacity, depending on the degree of severity of the disorder. However, the concealment of drug addiction, habitual alcoholism, lesbianism or homosexuality is a ground of annulment of marriage. Parental authority, child under 7 years of age. Under Article 213 of the Family Code, no child under 7 years of age shall be separated from the mother unless the court finds compelling reasons to order otherwise. The rationale of the second paragraph of Article 213 of the Family Code is to avoid the tragedy of a mother who sees her baby torn away from her. It is said that the maternal affection and care during the early years of the child are generally needed by the child more than paternal care. Hontiveros v. IAC, GR number 64982, October 23, 1984, Tolentino, Commentaries and Jurisprudence on the Civil Code, Volume 1, pp. 718 to 719. The general rule is that a child below 7 years old shall not be separated from his mother due to his basic need for her loving care. Espiritu B. CA. GR number 115640, March 15, 1995. Compelling reasons which justify the taking away from the mother's custody of her child under 7 years of age. A. The mother is insane. SEMPOD, Handbook on the Family Code of the Philippines, pp. 296-297, the mother is sick with a disease that is not communicable and might endanger the health and life of the child. The mother has been maltreating the child. The mother is engaged in prostitution. The mother is engaged in adulterous relationship. The mother is a drug addict. The mother is a habitual drunk or an alcoholic. The mother is in jail or serving sentence. Parental authority, special parental authority, liability of teachers. The school, its administrators, and teachers have special parental authority and responsibility over the minor child while under their supervision, instruction or custody. Article 218, FC. They are principally and solidarily liable for the damages caused by the acts or omissions of the unemancipated minor unless they exercised the proper diligence required under the circumstances. Article 219, FC. In the problem, the teacher and the school authorities are liable for the blindness of the victim, because the student who caused it was under their special parental authority and they were negligent. They were negligent because they were chatting in the corridor during the class period when the stabbing incident occurred. The incident could have been prevented had the teacher been inside the classroom at that time. The guilty boy's parents are subsidiarily liable under Article 219 of the Family Code. Parental authority, substitute versus special. In substitute parental authority, the parents lose their parental authority in favor of the substitute who acquires it to the exclusion of the parents. In special parental authority, the parents or anyone exercising parental authority does not lose parental authority. Those who are charged with special parental authority exercise such authority only during the time that the child is in their custody or supervision. Substitute parental authority displaces parental authority while special parental authority concurs with parental authority. Paternity and filiation. A. The child is legitimate to the second marriage under Article 168(2) of the Family Code, which provides that a child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within 300 days after the termination of the former marriage. Paternity and filiation proofs. B. To be able to inherit the illegitimate filiation of Nestor must have been admitted by his father in any of the following. 1. The record of birth appearing in the civil register. 2. A final judgment. 3. A public document signed by the father, or 4. A private handwritten document signed by the latter. Article 17s in relation to Article 172 of the Family Code. Paternity and filiation, artificial insemination formalities. Andy is the biological father of Alvin, being the source of the sperm. Andy is the legal father of Alvin because there was neither consent nor ratification to the artificial insemination. Under the law, children conceived by artificial insemination are legitimate children of the spouses provided that both of them authorized or ratified the insemination in a written instrument executed and signed by both of them before the birth of the child. Art. 164 Family Code. The following are the requirements for Ed to establish his paternity over Alvin. The artificial insemination has been authorized or ratified by the spouses in a written instrument executed and signed by them before the birth of the child, and the written instrument is recorded in the civil registry together with the birth certificate of the child. Art. 164, second paragraph, Family Code. Paternity and filiation, common law union. ZMN was legitimated by the subsequent marriage of RN and DM because at the time he was conceived, RN and DM could have validly married each other. Under the Family Code, children conceived and born outside of wedlock of parents who, at the time of the former's conception, were not disqualified by any impediment to marry each other are legitimated by the subsequent marriage of the parents. Paternity and filiation, proofs, limitations, adopted child. 1. Under Art. 172 in relation to Art. 173 in Art. 175 of the FC, the filiation of illegitimate children may be established in the same way and by the same evidence as legitimate children. Art. 172 provides that the filiation of legitimate children is established by any of the following. 1. The record of birth appearing in the civil register or a final judgment. Or 2. An admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned. In the absence of the foregoing evidence, the legitimate filiation shall be proved by 1. The open and continuous possession of the status of a legitimate child. Or 2. Any other means allowed by the rules of court and special laws. 2. No, since Danilo has already been adopted by Carlos, he ceased to be an illegitimate child. An adopted child acquires all the rights of a legitimate child under Art 189 of the FC. 3. No, he cannot. Danilo cannot represent Carlos as the latter's adopted child in the inheritance of Abraham because adoption did not make Danilo a legitimate grandchild of Abraham. Adoption is personal between Carlos and Danilo. He cannot also represent Carlos as the latter's illegitimate child because in such case, he is barred by Art. 992 of the NCC from inheriting from his illegitimate grandfather Abraham. Paternity and filiation, recognition of illegitimate child. No, Joey does not have a cause of action against Tintin for recognition and partition. Under Article 175 of the Family Code, as a general rule, an action for compulsory recognition of an illegitimate child can be brought at any time during the lifetime of the child. However, if the action is based on open and continuous possession of the status of an illegitimate child, the same can be filed during the lifetime of the putative father. In the present case, the action for compulsory recognition was filed by Joey's mother, Dina, on May 16, 1994, after the death of Steve, the putative father. The action will prosper if Joey can present his birth certificate that bears the signature of his putative father. However, the facts clearly state that the birth certificate of Joey did not indicate the father's name. A birth certificate not signed by the alleged father cannot be taken as a record of birth to prove recognition of the child. Nor can said birth certificate be taken as a recognition in a public instrument. Reyes v. Court of Appeals GR number 39537, March 19, 1985. Consequently, the action filed by Joey's mother has already prescribed. Yes, the defenses of Tintin are tenable. In Tayag v. Court of Appeals GR number 95229, June 9, 1992. A complaint to compel recognition of an illegitimate child was brought before effectivity of the Family Code by the mother of a minor child based on open and continuous possession of the status of an illegitimate child. The Supreme Court held that the right of action of the minor child has been vested by the filing of the complaint in court under the regime of the Civil Code and prior to the effectivity of the Family Code. The ruling in Tayag v. Court of Appeals finds no application in the instant case. Although the child was born before the effectivity of the Family Code, the complaint was filed after its effectivity. Hence, Article 175 of the Family Code should apply and not Article 285 of the Civil Code. If Joey died during the pendency of the action should still be dismissed because the right of Joey or his heirs to file the action has already prescribed. Art 175 Family Code. Paternity and filiation, rights of legitimate children. Under the fact stated, X and Y are legitimate children of B and C. E is the legitimate children of B and G. E is the legitimated child of B and G. F is the illegitimate child of B and C. As legitimate children of B and C, X and Y have the following rights. 1. To bear the surnames of the father and the mother, in conformity with the provisions of the Civil Code on surnames. 2. To receive support from their parents, their ascendants, and in proper cases, their brothers and sisters, in not conformity with the provisions of the Family Code on support, and 3. To be entitled to the legitimacy and other successional rights granted to them by the Civil Code. Article 174 Family Code. E is the legitimated child of B and G under Art 177 of the Family Code. Only children conceived and born outside of wedlock of parents who, at the time of the conception of the former, were not disqualified by any impediment to marry each other may be legitimated. He will have the same rights as X and Y. F is the illegitimate child of B and G. F has the right to use the surname of G, her mother, and is entitled to support as well as the legitimacy consisting of one half of that of each of X, Y and E. Article 176 Family Code. Property relations, absolute community. 1a. Yes, the Family Code provides that all property acquired during the marriage, whether the acquisition appears to have been made, contracted, or registered in the name of one or both spouses, is presumed to be absolute community property unless the contrary is proved. B. Yes, The shares are presumed to be absolute community property having been acquired during the marriage despite the fact that those shares were registered only in her name. Alberto's right to claim his share will only arise, however, at dissolution. C. The presumption is still that the shares of stock are owned in common. Hence they will form part of the absolute community or the conjugal partnership depending on what the property relations is. D. Since Paulita acquired the shares of stock by honoris title during the marriage, these are part of the conjugal or absolute community property. As the case may be, depending on whether the marriage was celebrated prior to or after the effectivity of the family code. Her physical separation from her husband did not dissolve the community of property. Hence the husband has a right to share in the shares of stock. 2. Under a community of property, whether absolute or relative, the disposition of property belonging to such community is void if done by just one spouse without the consent of the other or authority of the proper court. However, the land was registered in the name of Paulita as widow. Hence the buyer has the right to rely upon what appears in the record of the Register of Deeds and should consequently be protected. Alberto cannot recover the land from Rafael but would have the right of recourse against his wife. B. The parcel of land is absolute community property having been acquired during the marriage and through Paulita's industry despite the registration being only in the name of Paulita. The land being community property, its sale to Rafael without the consent of Alberto is void. However, since the land is registered in the name of Paulita as widow, there is nothing in the title which would raise a suspicion for Rafael to make inquiry. Therefore, is an innocent purchaser for value from whom the land may no longer be recovered. C. No. Rafael is an innocent purchaser in good faith who, upon relying on the correctness of the certificate of title, acquires rights which are to be protected by the courts. Under the established principles of land registration law, the presumption is that the transferee of registered land is not aware of any defect in the title of the property he purchased. See Tajonera v. Court of Appeals 103 SCRA 467. Moreover, the person dealing with registered land may safely rely on the correctness of its certificate of title, and the law will in no way oblige him to go behind the certificate to determine the condition of the property. Director of Lands v. Abash et al. 73 Phil. 606. No strong considerations of public policy have been presented which would lead the court to reverse the established and sound doctrine that the buyer in good faith of their registered parcel of land does not have to look beyond the Torrens title and search for any hidden defect or inchoate right which may later invalidate or diminish his right to what he purchased. Lopez v. Court of Appeals 189 SCRA 271. D. The parcel of land is absolute community property having been acquired during the marriage and through Paulita's industry despite registration only in the name of Paulita. The land being community property, its sale to Rafael without the consent of Alberto is void. Property relations, anti-nuptial agreement. Since Tirso and Tessie were married before the effectivity of the family code, their property relation is governed by conjugal partnership of gains. Under Art. 54 of the Civil Code, the share of the hidden treasure which the law awards to the finder or the proprietor belongs to the conjugal partnership of gains. The 1/2 share pertaining to Tessie as owner of the land, and the 1/2 share pertaining to Tirso as finder of the treasure, belong to the conjugal partnership of gains. Property relations, conjugal partnership of gains. 1. Since Bob and Sophia got married in 1970, then the law that governs is the new Civil Code, persons, in which case the property relations that should be applied as regards the property of the spouses is the system of relative community or conjugal partnership of gains, Article 119, Civil Code. By conjugal partnership of gains, the husband and the wife place in a common fund the fruits of their separate property and the income from their work or industry, Article 142, Civil Code. In this instance, the lot inherited by Bob in 1975 is his own separate property, he having acquired the same by lucrative title par. 2. Art. 148, Civil Code. However, the house constructed from his own savings in 1981 during the subsistence of his marriage with Isa is conjugal property and not exclusive property in accordance with the principle of reverse succession provided for in Art. 158, Civil Code. 2. Yes, the answer would still be the same. Since Bob and Isa contracted their marriage way back in 1970, then the property relations that will govern is still the relative community or conjugal partnership of gains, Article 119, Civil Code. It will not matter if Bob died before or after August 3, 1988, effectivity date of the family code. What matters is the date when the marriage was contracted. as Bob and Isa contracted their marriage way back in 1970. The property relation that governs them is still the conjugal partnership of gains. Art. 158, Civil Code. Property relations, marriage settlement, conjugal partnership of gains. The marriage settlement between Gabby and Mila adopting the regime of conjugal partnership of gains still subsists. It is not dissolved by the mere agreement of the spouses during the marriage. It is clear from Article 134 of the Family Code that in the absence of an express declaration in the marriage settlement, the separation of property between the spouses during the marriage shall not take place except by judicial order. The regime of conjugal partnership of gains governs the properties acquired by the spouses. All the properties acquired by the spouses after the marriage belong to the conjugal partnership. Under Article 116 of the Family Code, even if Gabby registered the mansion and 5-hectare agricultural land exclusively in his name, still they are presumed to be conjugal properties, unless the contrary is proved. Since all the properties are conjugal, they can be held answerable for Mila's obligation if the obligation redounded to the benefit of the family. Art. 121, Family Code. However, the burden of proof lies with the creditor claiming against the properties. Ayala Investment Fee Court of Appeals, GR number 118305, February 12, 1998, reiterated in Homeowners Savings and Loan Bank v. Dalo, GR number 153802, March 11, 2005. A family home is a dwelling place of a person and his family. It confers upon a family the right to enjoy such property, which must remain with the person constituting it as a family home and his heirs. It cannot be seized by creditors except in special cases. Taneo Jr. v. Court of Appeals, GR number 108532, March 9, 1999. Property relations, marriage settlements. A. Yes, it is valid as to form because it is in writing. No, it cannot be registered in the Registry of Property because it is not a public document. To make it registerable, it must be reformed and has to be notarized. B. Stipulations 1 and 3 are valid because they are not contrary to law. Stipulation 4 is void because it is contrary to law. Stipulation 2 is valid up to 1/5 of their respective present properties but void as to the excess. Art. 84, Family Code. C. No. On September 15, 1991, the marriage settlement is not yet valid and enforceable until the celebration of the marriage to take place before the last day of the 1991 bars examinations. Property relations, marriage settlements. 1. Since the marriage settlement was entered into without the consent and without the participation of the parents, they did not sign the document, the marriage settlement is invalid. Applying Art. 78 FC, which provides that a minor who according to law may contract marriage may also enter into marriage settlements, but they shall be valid only if the person who may give consent to the marriage are made parties to the agreement. Carla was still a minor at the time the marriage settlement was executed in September 1988 because the law, RA 6809, reducing the age of majority to 18 years took effect on the 18th of December 1989. The marriage settlement being void, the property relations governing the marriage is therefore absolute community of property, under Art. 75 of the FC. 2. All the properties which Kevin and Carla owned at the time of marriage became community property which shall be divided equally between them at dissolution. Since Kevin owned 50 million and Carla 2 million, at the time of the marriage 52 million constituted their community property. Upon the death of Kevin, the community was dissolved in half of the 52 million or 26 million is his share in the community. This 26 million therefore has his estate. 3. Carla and Luis are the intestate heirs of Kevin. 4. They are entitled to share the estate equally under Article 1001 of the NCC. Therefore, Carla gets 13 million and Luis gets 13 million. Property relations, obligations, benefit of the family. The levy is not proper, there being no showing that the surety agreement executed by the husband redounded to the benefit of the family. An obligation contracted by the husband alone is chargeable against the conjugal partnership only when it was contracted for the benefit of the family. When the obligation was contracted on behalf of the family business, the law presumes that such obligation will redound to the benefit of the family. However, when the obligation was to guarantee the debt of a third party, as in the problem, the obligation is presumed for the benefit of the third party, not the family. Hence, for the obligation under the surety agreement to be chargeable against the partnership, it must be proven that the family was benefited and that the benefit was a direct result of such agreement. Ayala Investment featuring 286 SCRA 272. Property relations, unions without marriage. A. Rico and Cora are the co-owners of the Riceland. The relations is that of co-ownership. Art. 147 Family Code, first paragraph. Optional addendum, however, after Rico's marriage to Letty, the half-interest of Rico in the Riceland will then become absolute community property of Rico and Letty. B. Rico is the exclusive owner of the coconut land. The relations is a sole single proprietorship. Art. 148 Family Code, first paragraph is applicable, and not Art. 147 Family Code. Optional addendum, however, after Rico's marriage to Letty, the coconut land of Rico will then become absolute community property of Rico and Letty. C. Rico and Letty are the co-owners. The relations is the absolute community of property. Arts 7590 and 9L Family Code. Property relations, unions without marriage. A. Art 147 of the Family Code provides in part that when a man and a woman who are capacitated to marry each other live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage, their wages and salaries shall be owned by them in equal shares, and the property acquired by both of them through their work or industry shall be governed by the rules of co-ownership. In the absence of proof to the contrary, properties acquired while they live together shall be presumed to have been obtained by their joint efforts, work or industry, and shall be owned by them in equal shares. A party who did not participate in the acquisition by the other party of any property shall be deemed to have contributed jointly in the acquisition thereof if the former's efforts consisted in the care and maintenance of the family and of the household. Thus, 1. The wages and salaries of Luis in the amount of P200,000.00 shall be divided equally between Luis and Ritza. 2. The house and lot valued at P500.000.00 having been acquired by both of them through work or industry shall be divided between them in proportion to their respective contribution, in consonance with the rules on co-ownership. Hence Luis gets 2.5 while Ritza gets 3.5 of P500.000.00. 3. The car worth P100,000.00 shall be exclusively owned by Ritza, the same having been donated to her by her parents. B. The property relations between Luis and Ritza, their marriage having been celebrated 20 years ago under the Civil Code, shall be governed by the conjugal partnership of gains, under which the husband and wife place in a common fund the proceeds, products, fruits and income from their separate properties and those acquired by either or both spouses through their efforts or by chance, and upon dissolution of the marriage or of the partnership, the net gains or benefits obtained by either or both spouse shall be divided equally between them. Art. 142. Civil Code. Thus, 1. The salary of Luis deposited in the bank in the amount of P200.000.00 and the house and lot valued at P500,000.00 shall be divided equally between Luis and Ritza. 2. However, the car worth P100.000.00 donated to Ritza by her parents shall be considered to her own paraphernal property, having been acquired by lucrative title par. 2. Art. 148 Civil Code. Property relations, unions without marriage. Tony and Susan are entitled to the house and lot as co-owners in equal shares. Under Article 147 of the Family Code, when a man and a woman who are capacitated to marry each other lived exclusively with each other as husband and wife, the property acquired during their cohabitation are presumed to have been obtained by their joint efforts, work or industry and shall be owned by them in equal shares. This is true even though the efforts of one of them consisted merely in his or her care and maintenance of the family and of the household. Yes, it would make a difference. Under Article 148 of the Family Code, when the parties to the cohabitation could not marry each other because of an impediment, only those properties acquired by both of them through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. The efforts of one of the parties in maintaining the family and household are not considered adequate contribution in the acquisition of the properties. Since Susan did not contribute to the acquisition of the house and lot, she has no share therein. If Tony cohabited with Susan after his legal separation from Alice, the house and lot is his exclusive property. If he cohabited with Susan before his legal separation from Alice, the house and lot belongs to his community or partnership with Alice. Subscribe, like and comments below.